Chapter 11 is all about preparing for prisoner reentry, discretionary parole, and mandatory release. Prisoner reentry. Prisoner reentry starts the day that offender is sentenced, or the day the offender is placed in prison or jail. That's our key goal. Get these people back into the community. So of offenders released from prison every year, about 80% of those people will remain on some type of community supervision. And 20% will serve their entire sentence behind bar. So in other words, people don't go to prison and stay there forever. Most people in prison will get out. So ask yourself, do you want them to come out being a little bit better than what they came in? Maybe coming out being a little more prepared to be a functional citizen? That's just something to ask yourself. So let me give you a formal definition of prisoner reentry. Prisoner reentry is any activity or program dedicated to preparing and integrating parolees into the community as law-abiding citizens. And what this takes is you use a collaborative approach with parole officers, treatment providers, and citizens. And the main goal of reentry is crime desistance. In other words, just stop doing crime. Yeah, just stop. Tell them just to stop. Stop it. See if that works. All right, there are a couple issues when we look at prisoner reentry. They're going to need an identification card. And I don't know if you've been to the DMV lately, but the DMV today is way different than it was 20 years ago. There are many documents required to obtain formal identification. They may need some clothes, some civilian clothes. They may need bus passes to get around, and they may need medication. And if you have offenders that need psychotropic medication, you definitely want to focus on having their medication when they're released. You might want to give them a list of referrals, especially for any kind of health care needs that they may have. You want to give them some referrals for employment and help them on their way to find suitable housing. Those are main issues with proper reentry. Some other issues. Avoiding substance abuse. I used to make sure I had my offenders come in within the first 48 to 72 hours to drug test them. I mean, because I put myself in their shoes. I tell my students all the time, think like a criminal, but don't be a criminal. But you got to think like a criminal. You've got to connect on a mental basis and be able to think like they think ahead of time so you can intervene. It's much easier to do a preemptive intervention than it is to go back and take a reactive approach and try to fix a problem once the problems are already there. So if you know you have an offender coming out with a drug addiction, let's take a proactive approach. Let's look at some treatment that they can get. Let's give them an AA or NA meeting list or something like that. So anything to avoid substance abuse. Because think of it this way. If you're an offender and you've been incarcerated for 10 years, what are the first things you're going to want to do when you are released from prison? Think about that. They may need transportation. You may want to help them, guide them in reunifying the family. There's some other issues. So that's reentry. Let's look a little bit about parole. Parole is a discretionary release of an offender, and that's the first step in the reentry process. But first of all, they have to be eligible for parole. So some inmates are permanently ineligible for parole, and those inmates are those that are sentenced to death or life without parole. There are some offenders called habitual offenders or 3 strikes offenders, where they're probably never eligible to get out. So how do we know when an inmate is first eligible for parole? Well, we look at the minimum eligibility date, and that's the shortest amount of time defined by statute that must be served before an inmate is considered for parole or by the parole board. Here's how that works. Let's say you have an indeterminate sentence of 3 to 5 years. What do you think the minimum eligibility date is going to be? Well, it's going to be 3 years in most jurisdictions. So at the 3-year mark, that offender is eligible for a parole hearing. Doesn't mean they'll get parole. It's up to the parole board, but that's at least when they become eligible. Maximum eligibility date is the longest amount of time that can be served before the inmate must, by law, be released. And that's what we refer to as maxing out. That's maxing out the sentence. So if you're working with these offenders, you want to do some pre-release preparation. And if you're in the community as a community corrections officer, if you're about to receive an offender, you'll get a pre-release plan probably 3 months before they're released from any kind of institution. And in that pre-release plan, you're going to have a tentative residence and tentative employment. So it's up to you to go out and do an investigation to see if, number one, it's an appropriate place to live. I mean, if there are guns in the house, you're not going to allow them to live there. It's just that simple. So it's about pre-release planning. And institutional pre-release planning goes beyond that. There are classes that they have the inmates take, pre-release classes that help them prepare for some of the problems that they'll have when they're released. Okay, so like I told you before, at the minimum eligibility date, the offender might come up before the parole board. So what are the functions of the parole board? There are 4 functions I want you to be aware of. First of all, they decide which prisoners to be released. That's a pretty big responsibility. Then, secondly, if they do release, they determine what the conditions of release are. So they come up with conditions for supervision or any special conditions of supervision. Then, to successfully discharge the parolee when the conditions have been met. So that's the third thing. They release people from parole. The fourth thing is they determine revocation. Should this person be revoked or not? In addition to that, some parole boards will be involved in granting furloughs, executive clemency decisions, restoring civil rights, and granting reprieves in death penalty cases. So how do these hearings work? Well, there's usually a board. A parole board averages about 7 members, ranging from 3 to 19 in number. And the way you become a parole board member is the governor or the head of the Department of Corrections appoints members for usually an average of 5 years. And the qualifications vary. So as you can see, it's a political appointment, which I, from a professional standpoint, completely disagree with. There's too much political endgaming going on. And you may not always get the most qualified person to be the parole officer. So there's your board. Then you have a hearing. You can have a hearing in one of 3 ways. You can have it in person, which is the most common type. It's conducted in a prison, and the board members ask questions. Like, did you learn a lesson? Do you feel any remorse about what you've done? Things like that. The second option is video teleconferencing. This reduces the need for travel, and it is what it says it is. The parole board be in their office, and then they have see each other from closed caption television. Then there's a review of the file, which is the third type, and there's no need for face-to-face contact, and a decision is made simply by reviewing the offender's file. Now, one thing parole boards can or cannot, or don't have to, take into consideration is a victim impact statement. Some places, some parole boards actually are required to take a victim impact statement, some are not. So, does the parole board just, reach into a hat and make a decision about who they're going to release? No. Nowadays, they use what we call actuarial risk assessments. And so they'll look at the file and they'll do a salient factor score. They look at the behavior, the crime, the past experiences, and equate a number to certain things. And based on that number, they'll use that to make a decision about releasing them. We call these risk assessment tools or risk assessment instruments. And there are many different types of these types of instruments out there. But most usually, parole boards tend to use the salient factor score. It was designed or developed by the Federal Parole Commission. Even though there is not any federal parole, so keep that in mind, federal parole was abolished in 1984, so there is no federal parole. But just in case you're working for the state, let me give you 8 things that they tend to look for. They look at criminal identity, antisocial personality, early and persistence involvement in crime, other close associates, lack of nurturing, alcohol, drug use, things like that, and that goes so on and so forth. So the parole decisions, what helps determine the parole decision? the severity and the type of the offender's crime, the offender's prior criminal history, victim's input, maybe some offender's family input. Probability of recidivism is huge. But how do we know? I mean, how do we know if somebody's going to recidivate or not? It's pretty tough to look into the future and figure out individual behavior. Risk to the community, conduct of the offender while incarcerated, and the sufficiency of the release plan. And these are very important decisions that the parole board looks at when determining release. So their options: number 1, grant parole; number 2, deny parole; and number 3, defer parole. And that's where they say, we're not going to give you parole right now. We're going to re-examine your case maybe in about 6 months to a year. There's one big legal issue I want to bring up, and it's hearsay. And hearsay can be used in parole release decisions, but parole can't be denied for false, insufficient, or capricious reasons. So that's odd. I wanted to bring that up because of the oddity of it. You can't use hearsay in an actual court hearing, but the level of burden of proof is much different in a parole board hearing. So that concludes Chapter 11. Thanks for listening. Have a great day.